Ok. Done.
Pessoal, então vamos lá, rapidamente, para não ser deselegante em português. Né? Eu já tinha combinado com eles que a gente começaria não 8 horas pontualmente, mas todos entraram pontualmente, então não tem jeito, né? Vamos lá, mas a gente já está com um público muito bom. Agradeço a todos a presença de vocês, agradeço aos colegas por isso. A formatação vai ser aproximadamente meia hora, eles vão falar, e depois a gente vai abrir para questões. Primeiro, os organizadores vão fazer as questões e depois a gente abre para todo mundo. Fiquem todos absolutamente à vontade para fazer pergunta. O professor Rodovalho vai me auxiliar com o chat. Quem quiser fazer a pergunta oralmente, tranquilo. Eu vou só pedir que seja colocado ou a mão levantada ou a mensagem no chat para fazer a pergunta, para que o professor Rodovalho possa fazer o controle das ordens, das questões. E vamos todos aproveitar o momento, a gentileza dos dois professores, e temos aí também um professor de Cornell, que é um dos maiores processualistas dos Estados Unidos, que é o professor Kevin Klerman, que escreve muito sobre prova, muito sobre coisa julgada. Então, mais uma vez, agradeço a todos a atenção e gentileza da presença de vocês. Sorry, guys, for the Portuguese, but I'm sure you could understand most of it, right?
I got about 3 words.
Okay, that's great. That's awesome. Just a second, please. Okay, let's begin.
Okay.
It's a great pleasure to receive online today, in the future, please, in person, 2 foreign professors. We have here Professor Daniel Klerman from USC, University of Southern California, talking to us in the afternoon. We also have Professor Yun-Chien Chang, I hope the pronunciation is correct, from Sinica Academy, Taipei, Taiwan, talking to us in the morning. Thank you for that, Professor Chang. Thank you for accepting our invitation. This online talk is hosted by 5 institutions, 4 law schools or universities, and a civil procedure studies center. I thank for each of these institutions for helping us today. We have here PUC Rio Grande do Sul, Professor Luiz Reichstadt. I can't pronounce his name either, so that's okay. I'm sorry for that, Professor Luiz. We have here also Mackenzie. I'm the professor from Mackenzie. We have also Professor Assis and Professor Andrea. We have also here from the Civil Procedure Study Center, Professor Fernanda Tartucci. Thank you for being here. We have Professor Tiago Rodovalho from PUC Campinas. And we also have from Brasilia, IDP, Professor Rodrigo Becker. And of course, I thank Professor Marco Jobim from PUC Rio Grande do Sul. He was the guy that made everything happen. This Zoom room was the one, he was the one who put it together. He helped us with the folder of the talk. So thank you, Professor Jobim. Today in Brazil, settlements are a big thing, are a big issue. So, Professor Dan and Yun-Chien, your article was fascinating for us. But please consider that not everyone from our audience has read it. We are eager here to find out more about the research and the conclusions you have reached. We hope that next time you guys are here with us in person, so you could meet all of us, you could be in Brazil and know our country. But considering the pandemic, at least we can learn from you online. But that's enough from me. We are here to listen to you and learn more about settlement rates. So we begin with your talk, and later we will go to the Q&A. Once again, thank you. Welcome to our event. And now it's your turn. I understand that first is going to be Dan, right? Is that it?
Yes. So
Okay.
thank you, Louise. This is really a great honor to speak to you, and I think this may be the largest Zoom audience I've ever spoken to. So thank you, and I appreciate the interest you have in this topic. And we're very much looking forward to your comments and questions because we have as much to learn about settlement as hopefully we can tell you. We are in some ways at the beginning of this research, and we're still trying to really understand what we're doing. So I hope you will take this talk in the spirit we intended, which is some preliminary results that we are still trying to understand, and we hope you will help us with some ideas. Obviously, this is with Yun-Chien at Academica Sinica. So we will... Good. So a quick overview of what I'm going to be talking about. We have data, official data, about ordinary civil litigation from 23 of the 25 largest economies in the world. And we found a surprisingly large variation in settlement rates across countries. And we were especially surprised that many countries have settlement rates that are below 20%. France, Russia, Turkey, and I might also point out, according to our statistics, also Brazil, which for someone, especially me, coming from the United States, where settlement rates are usually thought to be well higher than 60 or 70%, finding such a huge variation and places where settlement rates are very low was a big shock to us, big shock to me especially. In general, we found that settlement rates are lower than people think. Even in the United States and in the UK, the settlement rate is almost certainly below 80%. And then we tried various ways to explain why there's such great variation in the settlement rates. And given the small sample size, we could only do simple correlations, but we did find some factors which are associated with higher settlement rates, including common law legal origin, early disclosure of information to the opposing party, high litigation costs and delay, and maybe, but probably not, fee shifting. And some of the implications of this for theory, some settlement models, such as the early mutual optimism models that were used in for example, in Priest and Klein's articles about selection, they assume that settlement rates, and they predict that settlement rates will always be higher than 50%, and that is not consistent with what we find. So that suggests some of those early models of settlement are probably wrong. And also, as many of you know, there's a large literature of which I have written and Yun-Chien has written about the selection of disputes for litigation and how litigated cases may be not representative of all cases. And that's probably true for high settlement rate countries, but for countries where the settlement rate is below 20%, maybe we don't have to worry so much about selection, and that makes empirical work easier. Okay, so that's a quick overview. Let me go into a little more detail. So the data we have come from official government statistics, usually from the judicial branch. We tried to get data from the 25 largest economies. You'll see we were more or less successful, but there were two countries we really couldn't get any data from, and there were a few countries where the data quality was not very high. We tried to look at data only from courts of first instance, from trial courts, so we weren't looking at appellate courts. We were looking in basically 5 years, recent years, 2013 to 2017. And we tried to look at ordinary civil courts and commercial courts. Where possible, we excluded small claims, cases using summary procedures, arbitration, family law, labor, administrative law. We tried to focus on what we think of as sort of the core contract, tort, property kind of disputes. In countries with federal systems like the United States, and I think also Brazil, we primarily use data from the state courts rather than the federal courts. where the bulk of ordinary litigation happens. Although in the United States, we did use some data from federal courts, and as well as data from 7 of the 12 most populous states. Okay, so this map shows you the countries that we analyzed. The colors relate to their legal origin, which is something we'll get to soon, but you can see these are the countries basically that you'd expect. We've got the large economies in the United States and Canada, in Europe, in the Far East, China, India, and of course, Brazil, the largest economy, Brazil and Mexico, the largest economies in Latin America. So one of the first things we found is it's really, really hard to define the settlement rate, both for practical data reasons and for theoretical reasons. In this, we follow seminal work that was done by Kevin Klerman's colleagues at Cornell, Ted Eisenberg, who's also studied the settlement rate, and basically says there is no one settlement rate. You always need to make estimates, and you always have to make judgments about what to include in both the numerator and the denominator. So we use 4 primary ways of calculating the settlement rate, which we call set 1, set 2, set 3, and set 4. And they differ in 2 different ways. One is, what do we count as settlements? The major problem we have in calculating the settlement rates is most government statistics don't consistently record settlements. So we divide settlements in government statistics into 2 categories. There are cases where it is clear that there's a settlement, where the government statistics says there's a settlement, or says there's a consent judgment, which is a judgment arrived at by settlement. But in most government record-keeping systems, including the United States, there is a large category of cases which we call possible settlements. So they're cases which were dismissed for lack of prosecution, where the plaintiff just stopped prosecuting the case, or where the plaintiff withdrew from the case, but there's no explicit record that the case was settled. And we call those possible settlements because we think it's quite likely a lot of those cases were settled. But of course, sometimes the plaintiff stops prosecuting because they give up and they realize they have a bad case, and they didn't get any money from the other side. They just stopped. They realized it wasn't worth going forward. So that's one key difference. What do you count as a settlement? Do you count only as settlements the things where the records explicitly say the case was settled? Or do you count as settlements categories like a withdrawal or dismissal for lack of prosecution, where it's possible, maybe likely that it's settlement, but there's probably a lot of other things in there as well. And then the other difference is, what do you put in your denominator when you are calculating the settlement rate? So one possibility is just put all the cases that the government authority happens to be collecting records on. That's what we call total cases. And that, of course, is going to include cases where there's been a contested judgment after a trial, where there's a default judgment, as well as the cases where there's settlements. But there's also a whole bunch of things that governments tend to record where we think, those aren't really on the merits terminations of cases, and maybe they shouldn't be included in the settlement rate. So we call that other category the other resolutions. They would be things like a case that was dismissed for lack of jurisdiction, where maybe the person's going to file someplace else and the case will go on, just not be part of that government record. Or a referral to arbitration, where it'll be resolved in a different forum. Or a case which is transferred from one court to another. So the question is there, well, what should be in the denominator? Should it be all cases, or should we exclude those other resolutions? And by looking at those 2 different ways of thinking at the numerator and the denominator, we get 4 different ways of defining the settlement rate. Settlement 1 is clear settlements over total cases. Set 2 is clear settlements plus possible settlements divided by total cases. And set 3 and set 4 are the same, but dividing by total cases minus other resolutions. And then for some countries, we do some other settlement rates, but I'm not going to focus on that here. So when you define things that way, the chart here shows you what the settlement rates look like. And of course, one thing you'll notice is these different ways of calculating the settlement rate give you dramatically different settlement rates. So just take the United States. If you look at the lowest measures of settlement rates, the set 1 and set 2, the settlement rate might be as low as 20%, because government statistics in the United States almost never say the case settled. They almost always say, well, there was a dismissal, and people infer that that was settled. Whereas, the high end of the range, it could be that the settlement rate is well over 60%. So first of all, we have really lousy data on settlements. And so, one thing that I think is important is just to see whenever people talk about the settlement rate, they're making a set of decisions about what to count that involves a lot of decisions that are going to introduce inaccuracies. In general, people who study the settlement rate of the United States focus implicitly count cases that what we call possible settlements as settlements, but that's almost certainly overestimating the settlement rate. So the top panel is countries, the bottom panel are different states within the United States. One of the things you can see, of course, looking at this is, even given the huge range there is in estimates for a single country, there still are dramatic differences between countries. So look at France. Even the highest estimate of the settlement rate in France is under 20%, and even the lowest estimate of the settlement rate in the United States is above 20%. So even with this huge inaccuracy that we see, there are clearly big differences between countries in the settlement rate. One way of seeing that a little bit more easily is we focus for most of the paper on the measure we call set 2, which is clear settlements plus possible settlements over total cases. And so you can see in this chart, which is a little bit cleaner, how the countries tend to stack up. And you'll see there are a set of countries with settlement rates well below 20%. And then there's a handful of countries, such as the United States, the UK, and Australia, where the settlement rate is over 50%. But there's a huge variation. And that, to me, is, if you don't believe anything in our paper, that's the one thing that I hope you believe and remember. Settlement rates vary dramatically across the world. We also did a little bit of work by subject matter. We don't have subject matter data for all countries. We do have it for some countries in the Far East, where the difference in settlement rates by subject matter is not very large. Maybe it's a little higher in tort and a little lower in property, but the differences aren't large. In the United States, there's very clear patterns. Tort judgments, tort settlement rates are almost higher in the always higher in the United States, and property judgments are much lower. And so one of the things you see is that when people think about the settlement rate in the United States being really high, it's probably because some of the first studies of settlement rates in the United States come from auto accidents and other tort litigation. And for that, it's true the settlement rate is about 90%, or at least plausibly 90%, but that's not representative of all litigation in the United States, and certainly not in the whole world. Okay, the other thing we did is we compared our estimates to estimates produced by a survey we ran. And I'll explain this somewhat complicated graph in a second. But the key thing is, those of you who do empirical work, sometimes when you do empirical work, you come up with your empirical work and then people say, well, of course, we all knew that before, that's obvious. So one of the things we wanted to do was head off that criticism by saying, okay, let's see what people at least thought they knew, and then compare that to what we found in the paper. So what this graph shows first are the squares and the diamonds. Those are our estimates of the settlement rate, set 1, set 2, set 3, set 4. So you can see for the US, those settlement rates are between 20 and 60. For France, they're under 20. And then each of the little circles, that was a survey response. We surveyed American law professors, not the greatest sample in the world, but a sample of something. And we asked them what they thought the settlement rate was in the US, Japan, and France. And one of the things you can see is they almost always overestimate the settlement. The little circles are way higher than the lowest estimates, and they're higher than most of even the higher estimates. And then what the other things you see here is the red bar, that's the mean of the survey estimates. As you can see, the mean is always higher than any of the estimates we have. And the box tells you the 25th percentile, the 50th percentile, and the 75th percentile of the survey estimates. And you can see, even the 25th percentile is at best, only the 25th percentile for US and Japan is a decent estimate. And for France, American law professors just can't believe how low the settlement rate is in France. It's unfathomable to us. It's beyond what we would think. Okay, so what I think this shows, the main thing this I think shows is the results we have here are a surprise, at least to American law professors. One of the things that's quite clear about the settlement rate is that it varies by legal origin. And so as many of you know, there's a big literature in the last decades that talks about how countries that have common law legal systems from the United States and Britain mostly, are different than those that have legal systems that are based on the French civil law or based on German civil law or a small group of Scandinavian countries. And although Yun-Chien and I are both a little bit skeptical about this line of research, it's hard not to see that there's something going on here about legal origin and settlement rates. The common law countries almost all have higher settlement rates than the civil law countries. So each circle in this graph, that's a country, and the box is the 75th and the 25th, 50th, and 75th percentile in the median. And as you can see, the 25th percentile of the common law countries is above the median for the German civil law countries and above the 75th percentile for the French civil law countries. So there is a huge difference by legal origin. And part of what we try to explain in this paper is, well, what part of legal origin is what influence? What part of the difference between legal systems is driving these different settlement rates? So one thing we look at is disclosure rules. It's very common in common law countries, but also in some other parts of the world, that the parties are required to disclose to the other side the evidence that they plan to use to prove their case very early on. Whereas in other countries and other legal systems, you don't have to present your evidence to the other side until you present it to the judge. And our view, and this is consistent with the economic literature on settlement, is that early disclosure promotes settlement. One of the things that makes settlement hard is when people have different evidence and they don't know the real strength of their case and the strength of the opposing party's case. That asymmetric information makes settlement difficult. And so when you have early disclosure and you know the information the other side has, well, it's much easier to settle because you're settling based on common information and you can make a better guess as to what a judge will do. We also looked at fee shifting. And as you can see, there's not a whole lot of difference. The loser pays system is associated with slightly lower settlement rates. But as you can see, there's a huge overlap between fee shifting and settlement rates. We also looked at litigation costs. As you can see, litigation costs are all over the map. The litigation costs tend to be very high, say in the United States and the UK, and oddly Indonesia. They tend to be pretty low in other places. It's hard, you can't draw a really simple line here, but if you do analyze this a little more rigorously, there is some relationship between litigation costs and the settlement rate. That is, higher litigation costs lead to higher settlement rates. And that's in accord with the literature on settlement, which suggests, well, if litigation is really expensive, that gives a bigger incentive for the parties to settle. If it's relatively cheap to go to judgment, well, people may go to judgment. We also looked at delay in settlement rates, and there isn't a dramatic correlation, but it does tend to be that places where there's longer delay, there is more settlement. Partly it's just there's more time for the parties to settle, and partly it may be that if plaintiffs are especially have high discount rates, that may make it easier to settle. So those are the four basic factors we looked at: early disclosure, common law versus civil law, fee shifting, litigation costs, and delay. I guess that's 5 factors. And we think that partly explains the differences in settlement rates, but we don't think that's the whole explanation. And we're eager to hear if you guys have other suggestions as to what the what might explain differences in settlement rates. So in the last part, I just want to talk a little bit about implications of this research. Both Yun-Chien and I have done a lot of work on the theory of settlement, and so we're very interested in what this research suggests for the theory of settlement. And in the theory of settlement, there's two basic economic models of settlement. There's an older set of models, which are called mutual optimism models, and there are newer models, which are generally called asymmetric information models. And in general, the mutual optimism models predict much higher settlement rates, whereas the asymmetric information models generally are consistent with very low settlement rates. So to the extent that we find that some countries have very low settlement rates, that is more consistent with the asymmetric information models and less consistent with the mutual optimism models. Let me just explain briefly why that is. In the mutual optimism models, each party forms an estimate of the probability that the plaintiff's going to prevail, and they use that to estimate how much money they think they're going to get out of the litigation. And in the simplest mutual optimism models, like the one that was used in Priest and Klein's famous article about the selection of disputes for litigation, they assume that parties have random errors. The plaintiff is no more likely to err on the high side than the low side, and the defendant is no more likely to err on the low side than the high side. And if errors are randomly distributed like that, well, then half the time you expect the plaintiff's estimate to be lower than the defendant's estimate, and you expect the parties to settle. And that's why these models predict high settlement rates, because just by randomness, you'd expect there would be a settlement range at least 50% of the time. Nevertheless, these models can be modified to produce lower settlement rates. The most important one is a modification by Babcock and Lowenstein, which is, well, maybe people don't make random errors. Maybe people have self-serving biases. Maybe plaintiffs tend to overestimate their chances of winning, and defendants tend to underestimate the plaintiff's chances of winning. Well, then you can have very low settlement rates even with these mutual optimism models. And also, an important theoretical and empirical point, we can only measure the settlement rate for cases that are filed in court. But it's probable that many cases are settled before the case is ever brought to court. And if you added those pre-filing settlements, maybe that would be consistent even with the simple settlement models. And then the last theory we looked at was the selection of disputes for litigation. As I mentioned, there's a large literature starting with Priest and Klein in 1984 that suggests it's very misleading to look at published cases and very misleading to look at trial outcomes because trials are unrepresentative of all cases, because they argue most cases settle. So you're only, as they say, at the tip of the iceberg. And one of the things we suggest here is, well, that's true for countries like the United States and Britain and Australia and maybe even Germany, where settlement rates are pretty high. But in countries where the settlement rate is low, well, the litigated cases are pretty much all the cases, and maybe we don't have to worry so much about selection effects. And we did two estimates of how big selection effects might be using our data. One, what you've got on this slide is the biggest possible variance that could come from settlement rates. So this is assuming at the high end that every settled case would have been a plaintiff victory, and at the low end that every settlement would have been a defense victory. And so we're calculating here what is the plaintiff's overall success rate. So the red dots are what we see from the litigated cases, and you can see in this sample, which is mostly East Asia but also Germany, plaintiffs win over 50% of the cases at trial. And Priest and Klein would say, oh, don't worry at all about that. That doesn't tell you anything about whether the courts are biased for the plaintiff or whether the law is in favor of the plaintiff. That doesn't tell you anything because there's so many settled cases, you can't really learn anything from the litigated cases. But what happens is if you look in Taiwan and South Korea, even if you take into account the possibility of settlement, the lowest possible plaintiff win rate is over 70% in Taiwan and over 50% for most years in South Korea. And unless you assume like over 60 or 70% of the cases in Japan that are settled would have been plaintiff victories, the plaintiff win rate would have been over 50%. So this suggests, maybe we don't have to worry so much about selection effects. And we can portray that even more dramatically if we make some modeling assumptions about how settlements happen. So if we assume one of the most influential settlement models, the Bebchuk screening model, and we make some assumptions about how cases are distributed. I'm not going to go into the details, but this is a well-known model, and we assume a uniform distribution, which is a pretty standard distribution. Well, you can see here we've got the red dots are the observed plaintiff trial win rate, and the X's are what we call the corrected win rate, what the model would say the win rate would be if we could include and know the outcome of the settled cases. And you can see for Japan, South Korea, Taiwan, there's not that big a difference between the win rates corrected for selection and with just the raw data. And that's especially interesting for Japan because Japan is one of the relatively high settlement rate countries. It's about fifth in the rankings in the early on. On the other hand, Germany, which also has a pretty high settlement rate because its plaintiff trial win rate is relatively low to begin with, well, then corrected for settlement, we can't tell anymore whether the plaintiffs would have won more or less than 50%. Okay, so in conclusion, we find very large variation in the settlement rates. We've got some countries like France, Russia, Turkey, Brazil, where we estimate the settlement rate is below 20%. And we've got other countries like Japan, the US, the UK, Australia, where we estimate the settlement rate is over 50%. These differences can be explained partly by legal origin, with common law countries having higher settlement rates, and also by disclosure rules, litigation costs, and delay. And this has some implications for the theory of settlement and for empirical study of legal systems. Simple mutual optimism models are probably wrong. So simple models like Priest and Klein, as I mentioned, we can modify those models, but the simplest models are probably wrong because they're not consistent with low settlement rates. And selection effects are probably small enough that in some countries, especially countries with low settlement rates, we probably don't need to worry so much about selection effects. We can look at litigated cases and be pretty confident that we're looking at the legal system as a whole. And as I said, this is still very preliminary research. We're still struggling to understand why settlement rates are so low in many countries. As I said, especially for me coming from the US, this is a big surprise. And also, why is it that lawyers so often overestimate the settlement rates? Why is there such a big distinction between what lawyers, at least in the US, perceive the settlement rate to be and what it actually is? Well, thank you very much. I look forward to your comments and suggestions.
Dan, thank you very much. It was really interesting. I have read the paper, but of course, since you were explaining and lots of the data I couldn't understand, and now I could. So I think that the ones who did not read the paper before are better than me that read the paper before. Let's check that later. But let's then begin with the questions and answers. Allow me to begin with a question that when I read at first the paper, I said, whoa, what's happening? What's going on with what I have read? We know that Brazil does not have a high settlement rate. You have found out that, but let's figure something. In the US, the research showed that the rates are lower than usually people say. But okay, they are, even though they are high. Could the higher rate of agreements let's get US, be attributed to the insecurity of the judgment, especially from the jury trial. In Brazil, we would say something like legal uncertainty. I don't know what's coming from the jury. So let's settle. Do you think that is that a reason because in the US you have high rates? Why am I asking that? Because
I'm a little suspicious of culture as an explanation. I often think that culture is the result of material conditions rather than the producer. I mean, that way, I guess I'm a bit of a Marxist. I think of culture as the product of material and economic incentives rather than what produces it. And I think actually the settlement data is consistent with that, because if you think about these countries in their general views about, are these countries which value consensus and harmony, or are these countries that value conflict and individualism, there's not a whole lot of correlation overall with those on those dimensions. So the United States is usually seen as a country which has a lot of emphasis on individualism. We are very conflict prone, as evidenced by high gun ownership, and are resolving a lot of disputes violently. And yet we have a high settlement rate. And if you look at countries like Japan and China, which are seen as having cultures which are much more oriented towards consensual resolution of disputes, they have lower settlement rates than the United States. So I tend to think that what's driving settlement rates in these countries has less to do with culture overall than something about the structure of the judicial systems, whether it's the cost of litigation or whether it's disclosure or things like that. But in part that reflects the fact that I'm in large part a law and econ guy, so I tend to look at the economic factors rather than culture. But clearly once you're in a certain way, culture does sort of kick in. I think culture and economic incentives tend to reinforce each other. If you're in a legal system where the incentives are highly towards settlement, well, culture becomes a pro-settlement culture. So certainly in the United States, litigators are always working towards settlement. They just assume, of course, this case is going to settle, so they work up a case with the goal of settling it. And in a country where settlement rates are lower, well, that settles into people's expectations, and so I view culture more as reinforcing the economic and material incentives than being an independent explanation of settlement rates.
That was awesome. I'm gonna change my classes after your explanation. Yun-Chien, would you like to talk something about this culture thing? What do you think about that? Oh, here you are. Nice to meet you.
Nice to meet you. Well, I would say, unfortunately, I have nothing new to say because I tend to think along Dan's line. I think culture is kind of the result. So when I visit New York University School of Law, in the middle of conducting this analysis, I hire RAs, LM students from all these 25 or most of the 25 countries. And I ask them, in addition to find me the data in your country, I ask them various legal questions and then ask their personal experience of why people settle frequently or infrequently. So my RA from France says, of course, people don't settle. It's in our culture. And then in Japan, people say, of course, people settle. It's in our culture. It's kind of like the culture is the quick and dirty or the handy explanation for everything. And when they heard that other countries have relatively high or low settlement rates, they seem very much surprised. So this kind of the motivation for this paper, although we have very, very few observations, like 25 in terms of statistical power to test various reasons, I think we wanted to see whether it's the civil procedure rule or the court structure that would lead to the result that we find. For example, one thing that we consider but we ultimately cannot test is how lawyers are paid. My former colleague, Casey Huang, who got a JSD degree from Cornell Law School, supervised by Kevin, he had a study on why people don't settle in Taiwan. Well, because our baseline is the US, so our framing, his framing is that why people in Taiwan don't settle. And the reason he offers is that people in Taiwan, so his question is why in civil litigation, in cases where litigants are represented by attorneys, settle less frequently than litigants who are not represented by attorneys. So if you ask people in the US or some cynical person, they would say, of course, because attorneys charge by the hour. If they don't settle, then they could charge their clients more. That's kind of maybe the first thing they would say. But in Taiwan, most attorneys, no matter on the plaintiff side or on the defendant side, charge a fixed fee, and they collect the fee in advance. That is, until they are paid in full, they will not start doing any work. So the reason, like Casey offered, for the low settlement rates in Taiwan is that because the litigants, the thinking process is, I have paid you, my lawyer, everything, and then 3 days later you come back to me and say, let's settle. He would say, that's too easy. You get my easy money. So I would rather that you fight all the way, at least to the end of the first the trial of the district court or trial court or the district court render a decision. If that's not to my favor, we'll talk about settlement land. So that's kind of what, like, it's a case study of Taiwan of why people don't settle. That's because the fee structure makes the litigants who make the last who call the shots, not lean in the favor of settlements. But I'm sure other countries would have more or less same structural reason, but exhibit in different ways. But unfortunately, we don't have attorney fee arrangement in most of the countries, because even in Taiwan, we'll have to qualify that Casey's argument by saying, okay, corporations who hire elite business law firms are paid by the hour, while most others were paid fixed fee. And in the US, like in tort litigation, maybe the plaintiff attorneys take contingent fee, the defendant attorney may be charged by the hour, and then it's more difficult to account of whether it's the plaintiff side or the defendant sides that drive the settlement or non-settlement result. So that's my thought on your question, Luis.
Okay, that was awesome also. And comparing the French people and the people from the countries, it's great to understand what you two are explaining to us. Great. Professor Klerman, be our guest to ask for Professor Klerman and Chang, please.
Okay, Dan, could you go back to the survey results?
Sure.
Okay. This is just for a point of clarification. If you look at the US results, set 4 comes in lower than set 2.
Yeah. We'll have to check that out.
Yeah, mathematically that can't be, right?
Okay, we will check that. Thank you for checking that. Yeah, that.
Although you do it throughout.
It's true in Japan as well.
Yeah.
You know, that may be, that's probably my mistake. I may have just set up the code. I probably just set up the legend wrong.
Okay, I asked only to make sure I understood set 4 and set 2.
Yeah, we will.
On the survey results, how can you be sure that the lawyers were answering the same question that you were asking? In other words, I would think that if you ask lawyers or people what the settlement rate is, they're not going to really privilege the filing point. That in other words, they'll say, oh my God, yeah, the tort cases all settle. Well, they all settle because they settle before filing. And so consequently, they would estimate a much bigger figure than what you were calculating, which was post-filing settlement rates. And indeed, the reason I asked that is because I think that maybe one of the driving forces is the national disincentive to sue. That, as Yun-Chien said, that in Taiwan, when you sue, you're going to get a lawyer, and suddenly you're facing this big one-time fee. Well, then you're going to have quite an incentive to get this case out of the way if you can before you file. In France, I think filing or getting involved in the legal system is a real big step. And I don't think the French person would go to a lawyer until they're pretty sure that they want to sue and stay suing. That you don't sort of go to a lawyer to chat in France. So I'm wondering whether this gets back to your cultural point, but I wonder if the way the legal system is set up is such that it explains some of the, because the France-US distinction, man, that's a real eye-opener. I mean, I think this is great paper, so it's a real eye-opener. And you start wondering, maybe there's something different about the system. Sorry to go on, but those are my
that is good. That is a wonderful question, and you bring up really, really important points. And of course, the most important point you bring up is that there are certainly many pre-filing settlements, both in the U.S. and elsewhere, and we just don't have much data about them. We have a little bit of data on pre-filing settlements in the United States from studies of insurance companies, and there's a little bit of data on them in Japan and elsewhere. But it's a big problem with any empirical study of settlements that we don't have it. And you're right, the survey, one possible explanation for why the survey responses are so much higher is that people may be including pre-filing settlements. That's an excellent point. We've tried to address that in some parts that haven't made it into the paper yet, but let me tell you a little bit about how we're thinking about doing this. One way we're trying to do this is we do have some figures about how much litigation is there generally in these countries. Like what is the rate of filing per 1,000? And one of the things that's quite startling is that even though in the US we think of ourselves as a sort of litigious country, the rates of litigation are much higher in many other countries. And it often turns out that the countries which have very high rates of litigation are also the ones that have very low settlement rates, which is not consistent with the idea that there's a lot of pre-filing. So I think, for example, Russia has an enormous amount of litigation, and part of it has to do with litigation costs. Oftentimes what happens is countries with low litigation costs, they have people sue at the drop of a hat because it's cheap, and they don't settle because it's cheap. And so we will go back. We had done some work with this, and we'll need to go back to it. But I think that's certainly true in some places. So it may, for example, be in Japan, where I think you're right. There are some places where there's a real view that you only sue when the relationship is totally broken and where you've exhausted every other possibility. But I think there's a lot of countries in the sample, especially a lot of the ones with very low settlement rates, where low settlement rates go hand in hand with actually a fair amount of litigation. But we will investigate that. That's really good. The other thing we tried to do, and maybe we should go back and check on it, is we looked at filing fees. Now, obviously, the disincentive to settle comes not just from the monetary costs of filing, but also from the social costs of filing. But monetary costs are not trivial in many places, and my recollection is there was no connection between places like the United States, where filing fees are relatively trivial, and other countries where filing fees were a significant deterrent. We didn't find that had much relationship to settlement. You might have thought that in places with high filing fees, people would do all their settling beforehand, and therefore the cases that made it into filing, those would be the cases that wouldn't settle. But we don't find, we'll have to go back and reanalyze, but in our preliminary investigations, we didn't find that. Yun-Chien, do you remember either the data on filing rates or filing fees better than I do, and do I remember them correctly?
More More or less. I remember my two French RA told me maybe the opposite story that Kevin and Dan just described. They told me it's free to file litigation. So Dan is right that in France, there are a lot of filing because people think it's free. Why not? I'll just show the other party that I am kind of serious. I bother to file a litigation in court. But then in France, we have a hard time understanding the system, the records, because when it's free to file, people don't care to notify the court that they have settled. Because in Taiwan, Korea, and Japan, we pay a pro rata filing fee. And the Civil Procedure Act would say if parties settle before the judge rendered a decision, 2/3 of the filing fee will be returned. So people diligently report to court that, oh, we have settled. So please refund the filing fee. But in France, because it's free, most of the settlements that we have identified come from a category called like pause for 1 year, pause for 2 years. Because that's what the local people in France believe, that it's a settlement, but because people don't care to tell the court, when courts summon them or notify them, they just don't show up. And after 1 or 2 years, a lot of those cases will kind of be freezed. In Argentina, we heard about the same story, but because very bad grasp of the total number of filed litigation in Argentina, even though the Supreme Court of Argentina has given us something that suggests most of the many of the filed cases were kind of freeze after 1 or 2 years. We cannot use our usual formula to calculate set 1 to set 4. So that's part of the response to Kevin's great question. And the response to Kevin's question about what are we asking? So what were we asking? So when Dan sent out the survey through the civil procedure listserv, we put the question as, what is your best estimate of the settlement rates in the US federal court for diversity cases? And for France is, what is your best estimate of the settlement rates in France for ordinary civil cases? Claims with more than 10,000 euros at stake. So I guess the language would at least hint at post-filing settlement rates, because we asked the settlement rates in court. But as Kevin rightly suggests, the pre-filing part is kind of the devil's in all of the settlement rate studies. Casey Huang, again, and a Japanese professor, Masayuki Murayama, they have teamed up with some English scholars to do what they call, I think, dispute pyramid. So they survey people to calculate among every 10,000 disputes, how many of them like seek professional assistance, how many of them go to court, how many of them hang out to the final court litigation. I think in all of those places, the among 10,000 disputes, less than 1% of them receive a court judgment. But should we call the 99% settlement, or like give up in despair? I think there's a lot of a wide room for debate and a lot more research to do.
Just for the record, I wasn't suggesting the French fees were a disincentive. It was more the structure of the legal profession, that it's got a bifurcated legal profession like England. And so consequently, when you decide to go to court, it's a big step financially as well as psychologically. Okay.
So Louise, you want to call on some other people?
Professor Klerman, there was an amazing lecture. I'm from the PUC, the Rio Grande do Sul, from the south of Brazil. And I was thinking about your lecture and about the paper that I read before. And I have a question about something that may be implied in the method, or maybe it's a choice, a random choice, I don't know. I'd like to hear about that. In the paper, you and Professor Chang say that where possible, we collected data from ordinary civil courts and commercial courts and excluded small courts. Cases resolved using summary procedures, arbitration, family law disputes, labor disputes, and courts that specialize in such disputes. And to me, thinking about the Brazilian experience, it seems that a lot of settlements happen in small claim courts, especially related to consumer law. I don't know if you have an idea about what kind of impact it might produce, considering the results you have shown us on subjects related to settlement. I'd like to hear you and Professor Chang about that.
That's really wonderful. Oh, I'm sorry. Did you?
No,
I think that's a wonderful question, and I very much hope that that people will investigate that. For this paper, we decided to focus on sort of the bigger cases because that was had been the focus of some of the earlier work in the United States on the settlement rate in the United States, and so we wanted to sort of extend that to other countries. But as you point out, there are many other types of courts. There are small claims courts, there are labor courts, there are administrative courts in many places. There's also the question about settlements on appeal. And I think these are all terrific questions to investigate. But we just, to make things manageable, we decided to focus on one group of cases. I think we do have, by accident, we gathered some data on small claims. I don't know if we've analyzed it to have even a rough sense about it. Yun-Chien, do you know, did we look at any of the small claims or summary procedure data to see what the settlement rate was in some of those cases?
We already have Korea, Japan, Taiwan, Germany data on small claims, but we have seen some data from other countries, but we don't code all of them. As I recall, the main reason for excluding small claim is for consistency sakes, because in some, there are more variation in how small claims cases were handled. Some were part of the court, some forum were part of the court system in some countries. In some other countries, like of the peace would take care of small claim cases. They don't always have very good record keeping in small claim cases. So if we mixed in or include small claim cases, it would be a more difficult statistical task to do. But on the other hand, there are also disadvantages in excluding small claim cases, because like in Japan, Korea, and Taiwan, the definition of small claim differ, like a threshold. But you could say we could adjust for GDP, but even if we adjust for that, the threshold is still not the same. So we have truncated the cases on the low end without using the same threshold. And in some countries, I think Russia or France or both, we have no way to exclude small claim cases because they're just part of the overall statistics. But that's clearly recorded in our very long, much longer than the tax appendix for people to review. And from my impression, if we include small claim cases in Korea, Japan, and Taiwan, then settlement rates goes up. And then we anticipate that most of our audience or readers of the paper would say, well, you have very high settlement rates, like surprise, if people dispute over like $100 US, of course they will settle. So we don't want that kind of, you don't tell me anything new response, so that we decide to focus on higher stake cases. Is that okay?
Well, can I speak now? Well, first, thank you, Professor Klerman, Professor Chang. Thank you very much for giving this lecture for us. It has been a pleasure. It has been very interesting. Before I go for my question, I would like to ask Professor Chang, because we know you have to leave earlier. If you need to leave now, or if you want to uh, say some words to close your lecture here before you leave us, Professor Chang, please.
I'll leave in 20 minutes, so we still
I mean,
have time.
okay, so we have time. So first, we have a lot of questions from the audience. We thank very much for the questions. I don't know if I'll be able to make them all the questions for the professor. First, I would like to make one of my questions. It's a little bit in the line with the Professor Delotti question. Professor Delotti asked about the jury trial. Yes, and that's, of course, there is an impact. And also, we have listened here, Professor Klerman, Professor Chang, talking about the litigation cost. And that's, of course, one major factor about when we think about litigation. But here in Brazil, and Professor Fernando Tertucci, for instance, works with this, we need to have like a very accessible justice, because we are a poor country. We have a lot of issues here. We have a not very functional state. So, of course, when you have like a very strong democracy like US, like in some other countries, you can have like a more expansive justice. But for a young country, a young democracy like us, we need to be a more accessible justice. So litigation cost is also a very complicated issue here when we talk about Brazil. But we can think about another perspective, the cost of the outcome. And perhaps this we could change in Brazil. This is a discussion that we have here. And what is my point? Perhaps the punitive damage, perhaps they would be this changing factor, because when I think about the U.S. Model and some other common law models, not only the jury trial, but especially the punitive damages. For instance, this brings a lot of litigation cost for the litigation players, and then makes them to think more with the settlement. So this perhaps could be a factor, or perhaps a changing for countries that we could not make much expensive the cost, the litigation cost. So first I would like to listen about this. And also I would like to make another question because it's some kind of related. That is from Professor Fernando Gajardoni. He's a friend of many of the professors here. Professor Gajardoni is professor from the São Paulo University. He's a judge here in Brazil. And he made a question about the precedents. And the question of Professor Gajardoni is perhaps the stability and the predictability from the precedent. It's something that gives to the parties some a working space for the to settlement. In Brazil and a lot of civil law countries, you have like a more freedom for the judge to decide, and give this a lot of uncertainty to make an agreement. So those two questions, there is some kind of relate. I would like to address to both professors, Professor Klerman and Professor Chang, to listen a little bit. Thank you very much.
So thank you. That's both very interesting questions, and they're related. The punitive damages and the predictability themselves are I think, related. So I think the existence of punitive damages is partly why settlement rates are so high in torts in the United States, because they make things very expensive, because people are obviously going to fight harder if there's that much at stake, and they add to the unpredictability of it. Of course, in the United States, you can't give punitive damage in contract cases, or for the most part in real estate cases. And so, the settlement rate is still pretty high in the United States, even where there aren't punitive damages. And most other parts of even the common law world, like UK and Australia, have either no punitive damages or much more restrictions on punitive damages. So I don't think that can explain a large part of the variation. And certainly in China and Japan, which also have relatively high settlement rates, they don't have punitive damages. So part of the story, yes, but I don't think they can explain a lot of the variation across other countries. The issue of predictability, it's actually really interesting for me to hear it from you, because whether precedence in the common law system leads to more predictability or less predictability, it seems to depend on who you're talking to. So when you talk to German lawyers, they often say, oh, we've got a code here. Everybody knows exactly what's going to happen. And you Americans with your precedent, nobody knows what's going to happen. And the code leads to certainty, and juries and precedents lead to unpredictability. And it's interesting, you're saying sort of the opposite. You're saying, well, in Brazil, since you have a code and you don't have precedents, that it's much less predictable. And in general, I think the basic point is, and this goes back to what I said in the beginning, Yun-Chien and I don't tend to think that legal origin has a big independent effect. And that is, you can have predictability with codes, and you can have predictability with precedent. And you can have lack of predictability with codes, and you can have lack of predictability with precedents. It has a lot more to do with other factors in the legal system. Codes can be very well written, and codes can be poorly written, and that can lead to certainty. And codes can be supported by an apparatus of commentaries and predictable judicial interpretive methods, or they can't be. And similarly for precedents, how strong precedents are, how complete they are, how free judges feel to depart from them, I think is a lot more important than whether you have precedents or codes. That said, I think the question about determinacy or predictability of law is a lot less important than others probably do. And that's because, at least what I was taught when I was in law school, and I think it's largely true, by even comparative law professors, like some of you know John Langbein, who was one of my big teachers when I was at the University of Chicago and a student, he said, look, in most cases, the law is completely clear. Everybody knows what you need to prove in order to win a tort case in the United States. Everybody knows what you need to do in order to win a contract case. And yes, in law school, the professors try to trip you up by giving you all the most difficult legal questions in the universe. And that's good training for law professors, and I do the same thing to my students. But the real world of practice, the law is not that difficult. It's usually predictable. What's unpredictable are the facts. That's usually where the uncertainty comes from. And I think the facts are probably just as unpredictable in Brazil, in the United States, Germany, and Japan. That is, it's really hard to know what really happened. We all have our own perspectives on the world. The documents are ambiguous. People lie. People have bad memories. That's why it's hard to figure out how a case is going to come out. My guess is it has relatively little to do with the code or the precedents. But that's certainly a part of it. And but I think most of it is factual uncertainty.
So if I may, I think another facet of civil procedure that we're very interested in, and maybe Kevin could help us out here, is the level of burden of proof. So in like American texts, it would say, oh, the burden of proof in criminal procedure is beyond reasonable doubt, and in civil is more likely than not. If you want people to say, so can you translate more likely than not into like a percentage figure? Like some would say 50%, some would say a higher, like 85. And in Taiwan, usually people say 50. And in Japan, they say 80 or 85. But do they really mean the same thing? Do they measure 50% of burden of proof, 80, 85 in the same metrics? We don't know. But assuming that, for example, in Japan, people believe that they have to meet like an 80% or 85% burden of proof, they settle relatively high rates. That's understandable. And then they still win very often, which is less understandable. You have to assume certain kind of a selection to say, okay, people still file cases, but then they realize, oh, the pleading standard still is very high, so we settle. And for those people who don't settle, it's the winning cases that stay. So that given the high pleading bar, plaintiff in Japan still wins quite often. So that's something that we really want to measure, but we can't, because we can't rely on like civil procedure textbook to really tell us what's the real pleading bar. And that also applies to legal certainty. We have tried in our survey to our LLM lawyer students and say, so, is the law in your country predictable? So they can give us very interesting anecdotes, but they are not able to give us a measure of predictability on a common matrix across the world. Like we may need to design some survey experiments or maybe give real cases of same case factors to a lot of judges, lawyers, and scholars in various countries, and then say, how would this case come out in your country? And then look at the actual outcome and say, how often do they get it right? But that would be very hard to design and to satisfy the high standard of causal inference, I would say. Not to be depressing, but it's really hard to measure facets of civil procedure litigation across the world.
Okay, thanks. So, Professor Kevin Klerman, would you like to add something considering Professor Chang's mention, or no?
Sure. I guess I'd say first that according to Priest and Klein, the higher standard of proof should come out in the wash, because people would settle around that, and you'd expect exactly the same win rate at a high standard of proof as on a low standard of proof. As for the reality on the ground, there are a good number of people who claim that the civil law countries don't, in fact, apply the standard they claim to be applying, that it's down lower, and that the United States may be a little higher, so that the differences may not be that great. Nevertheless, the best reasoned position is that it is different, maybe not as different as we think. For example, in the civil law countries, they do apply the same standard of proof in the criminal as the civil cases. That's got an effect. I mean, France, for example, applies res judicata from the criminal side to the civil side. And so consequently, you lose the criminal case, you lose the civil case as well. So that clearly indicates that there is a difference between civil law and common law countries on the standard of proof.
Okay, thank you. Professor Rodrigo Becker from Brasilia, one of our co-hosts. Would you like to ask your question, please? Professor Becker, are you there?
Oh, sorry. My sound was unable, so sorry. Okay. Can you hear me? Yes? Oh, so first of all, I'd like to thank you, Professor Chang and Professor Klerman. It's a great pleasure to have you here online with us. And mainly speaking in name of EDP, it's the faculty of law that I am a professor here in Brasilia, the capital of Brazil. So once more, I'd like thank you so much for your presentation. It's different for us because we have never seen like nothing like this, like the rate of settlements and countries around the world. It's very, very, very good for us to know about that. So one of my questions was already answered when you were presenting your data. So I'm gonna change a little bit my approach to your research, Professor Klerman, strictly speaking about your research. So about the countries that you have researched. So it's more a curiosity. Have you had some troubles in finding data from some countries? And another one, have you even thought about research poor countries like African countries and like South America countries that have small economies? And that's my first question. And my second question is, it's approaching from my research here in Brazil, because I am a fan and I have a research group of the Supreme Court of the United States. So we have a research group in my faculty about the Supreme Court of the United States. I would like to know the second question about how you see the Supreme Court of the United States working, or how the Supreme Court of the United States can affect the settlement rates in U.S. Federal system. That's my two questions, and thank you very much for your both.
Excellent. So those are both really interesting questions. So the data is really hard to get. So you know, some countries are very transparent and they publish their judicial statistics online in pretty easily accessible places. And, you know, some places it's really, really hard to get the data. So, you know, we weren't able to get data from Argentina or Saudi Arabia. I tried really hard to get data from Saudi Arabia. I actually had some students who were from Saudi Arabia, and they were searching all over for the data, and there is some data, but it doesn't allow you to calculate the settlement rate. And even for some, you know, rich countries, which you might think would be more transparent, like Switzerland or the United States, we were only able to get data from some, you know, from some subdivisions. So, you know, in Switzerland, I think we only have data from 2 cantons. From the United States, we looked for the 12 biggest states, and we were only able to get 7 of them, and we were able to get data from New York. So the data is really hard, and that's why we look at 25 rather than you know, the entirety of the world, is just because it was so hard to get the data. We have talked about perhaps increasing, you know, maybe trying to get another 10 or so. It would increase our statistical power, and it would pick up some of the poorer countries that you mentioned. The disadvantages, the very brief searching we've done so far suggests that as you get to smaller countries, our success rate is likely to be lower. That is, we're likely to find that poorer countries are like Argentina and Saudi Arabia in that they just don't have statistics that we can use. But I think it would be great. I mean, part of what our hope is for this study is that this will not be the last study of comparative settlement rates, but that it will encourage people to do a variety of such studies. So it would be great if, you know, people whose language skills were better than ours did South America and, you know, look at all the different countries in South America, or did work in Africa. One thing just to notice, however, is, you know, some of these countries are relatively poor. India is a pretty poor country. It's a big economy because it's, you know, there's 1 billion people there. But it is a relatively poor country. Similarly for Mexico, Indonesia, Turkey, you know, there are countries here, and even China, although it's had spectacular growth, still has per capita income, I guess, is below Brazil's. So, you know, these are large economies, but they're not all necessarily rich economies. But that said, it would be great to study them, and we may do it, but we also encourage others to try to do it and see what they can find. In terms of the Supreme Court in the United States, its biggest effect on the settlement rate comes not through its individual decisions, but through the fact that it's the Supreme Court that writes the federal rules of civil procedure. And our view is that the rules of procedure, especially the rules about sharing of information, have a big effect on settlement rates. And so it's in that indirect way that we think that the Supreme Court affects things. You know, that said, there are, you know, ways, in smaller ways, the Supreme Court affects settlement rates. And so sometimes there are decisions that explicitly talk about, you know, we choose this rule rather than another rule because we think it will encourage settlement. I know a couple of years back when I was actually working at the Supreme Court, we decided a case based on using economic modeling of settlements to try to, create a rule we thought would encourage settlements. But I think that's relatively uncommon. I think it's mostly through the rules and the rules of evidence and the rules of procedure where the Supreme Court influences settlement rates.
Thank you very much, Professor Klerman. Am I able to make someone more one question, please?
Yeah, of course.
Have you ever know about some case in Supreme Court that had some kind of agreement in place of a final judgment?
Agreements in place of final judgment. So there are cases that, as the United States Supreme Court has a discretionary docket, so it chooses what cases to hear. But it does sometimes happen that after there has been the Supreme Court has decided to take a case that the parties settle. The thing is, usually when that happens, the Supreme Court will no longer hear the case. If the parties have settled, they simply won't continue to hear the case. And so it's a settlement, but it won't come down as a judicial opinion. There are times when the parties will agree on part of a case. They'll have a procedure that goes back to the 19th century where the parties will ask the Supreme Court just to decide the legal implications of settlement acts. But it would be unusual to have, it will be like a consent judge in the U.S. Supreme Court, because in general, the Supreme Court would say, look, if you guys will go back out, work at it with the lower courts. The Supreme Court of the United States has a different docket than many Supreme Courts around. The U.S. Supreme Court hears at this point roughly 100 cases per year, and it tries to reserve the cases that it hears for a very, very small number where that finding and opinion will have a salutary effect. It doesn't generally get involved in cases where there's.
So
Thank you very much, Professor, and thank you for all my colleagues to invitation of IDP or IDP to this presentation and this lecture. Thank you very much.
Thank you.
Professor Chang, you have to leave, right?
yes, I have to go, but one more thing to add. So Dan and I have looked at many more countries and jurisdictions than we have presented. Most of them, or I think all of them, leads to nothing. Like Hong Kong and Singapore, you would expect that small jurisdiction, super high GDP per capita, and not a lot of cases, they would keep a good record of settlement and whatnot. No, like Singapore, it's a country, very rich, almost no data. So we were very pessimistic about going deeper down the list of World Bank GDP ranking to find usable data. Thank you all for the invite. I have to run, sorry for that. And then you will handle the difficult questions alone. Bye-bye.
Thank you very much, Yun-Chien. That was great.
Bye-bye.
Dan, what about you? We have some more questions. Can we go on for a little? Okay,
I'm free for another hour. So whatever, I'm have as many questions as I can until the next half hour.
Okay, great. Professor Fernanda Tartus, it's your turn, please.
Hello, it was great hearing you. Thank you very much for all the explanations. Very interesting. Here in Brazil, we try to find just one factor, but we know so people can agree they have to have many things happening and everything must go right. So it was really great hearing you and your answers to the previous questions. I just have one question of mine. I'd like to know if you've had many researchers with you in this long journey of researching. I don't know how many people you could involve in this. And the second one is one from Luis Fontes in the chat. We have many compliments for you in the chat. People saying that it was excellent hearing you. But Luis Fontes asks, dear Mr. Dan, it was wonderful lecture. Thank you. I know it's difficult to predict, but would you believe that the settlement rates in general will be affected by the COVID-19 crisis? Thanks for your time.
That's a really interesting question. So you're right. This was a team effort. Many people were involved in the data. So already mentioned that he had several research assistants when he was at NYU Law School. Mostly they were LLM students from very different countries. So they really helped us understand and in some cases translate the documents, because my Turkish doesn't exist at all, and my French is okay, German is not great, and so it was really essential for us to have people who knew the languages, but also who understood the legal system, so we could know like what are the disclosure rules, or could help us read the statistical records. Even if we can get our hands on the statistical records of Switzerland, the legal system is different, and so we relied heavily on research assistants, graduate students at LLM, and also all our friends around the world who would help us answer questions about what's going on in Switzerland and why can't we find any data there. And also, I'm very grateful for a lot of work that I did. USC has wonderful librarians, which helped me with the data on US states. So for the US states, a lot of that information had to be specially requested from court administrators, and the librarians at my institution are great in that they know how to do what in the United States is called the Freedom of Information Act. So many states have a requirement that governments have to turn over information when it's about a lot of forms and things that have to be filed, and luckily I didn't fill out any of those forms, the librarians that I work with. So it was a big team, and we should have given more credit to the many people we worked with to made this possible. In terms of COVID, that's a really good question, and it's really tricky for a number of reasons. So a lot of the courts in the United States have been temporarily either closed or in virtual mode, and that has two offsetting effects on settlements. So on the one hand, if you're a defendant and things get drawn out, you might say, look, I don't want to settle. I can just take my time. Nothing's going to happen. And so that obviously can lower the settlement rate. On the other hand, plaintiffs, they want to get something out, so it may make it more that they are more interested in settlement. So it's part of the general issue of delay, and we did generally find in our paper that where there's greater delay, there is greater settlement, and so that would tend to suggest that COVID would increase settlement rates because it increases delay, but that's pure speculation. The other thing that's also a little bit tricky, and I know this in part from personal experience, my wife is a mediator. So, her job is to help people settle. Mediators have, for the most part, gone online. So she's gone 100% Zoom, and she's been pretty successful going. But a lot of mediations happened in person, and I think a lot of mediators were not able to shift to a Zoom model. And I think with less help, I think the settlement rate has fallen a little bit in certain, especially in smaller cases where the mediators were more likely to be on site than the bigger cases, which my wife deal with, where they move more easily to Zoom.
Okay, now Professor Marcelo Machado, your turn, please.
Hello, everybody. I have a question on legal origin. I believe it has been already answered, at least partially. Professor Klerman said that it is not essential to the paper to consider such characteristics. But, well, as a Brazilian and as a lawyer, I must say that I found it very strange to see the Brazilian law inside the classification of French civil law. It might be true to substantive law, but Brazilian procedural law is very similar to the Italian and in many ways to German law. And your paper, in a way, shows us that procedural law must be much more relevant to settlement than substantive law. So my question is, wouldn't it be more relevant to seek for those specific characteristics of institutions and efficiency of institutions, on predictability, on speed, and its correlation to the origin of the legal system? Because it doesn't say much to us to be put beside the French system, because we consider ourselves very different from the French, in the way our institutions work. For instance, in terms of complexity, Brazilian system is very complex. We have the federal laws, we have municipal laws, we have the state laws, and we have different characteristics in our society, including underdevelopment, that might put us in a very, very different situation. Consider the way judges judge and how adjudication is done in our country. So my question is it useful to make such an observation on the paper considering this legal origin?
So I think that's a very, very interesting approach, and I am generally share. I know Yun-Chien shares skepticism. Legal in a sense of and there's a colonialship between the origin country and the other countries. So the United States, Canada, India, Australia, they're all former colonies of it, and the legal systems were all, based, if you go back long enough, on the British legal system. And there's a fair amount of similarity that continues today. I think if you look in French West Africa, a lot of the laws were written by colonial masters and hadn't changed a whole lot. But as you point out, a lot more complex with South American countries, where you chose your laws for the most part and you rewrote them at the colonial period, and where you were never colonies of France, if you might have been colonies of Portugal and colonies of Portugal and Spain before they adopted the French civil code. And so there's no direct connection that. And I think the same criticism can be made for the classification of, say, Russia, Turkey as French law countries. And similarly, even the classification of German civil law countries, are Japan and China German civil law? Well, they borrowed a little bit, but they also borrowed a lot from the French. So I think the whole idea of legal families outside of the colonial context is a troubled one. That said, as skeptical as Yun-Chien and I are of it, it seems to have enormous power, as much as I don't want to believe it does. And so, even though, Russia and Turkey and Brazil are not really, pure French civil law countries, they share with French civil law very low settlement. Seems to be predictive for what we'd have difficulty explaining. But that said, because we're skeptical, we do a lot of the analysis that you suggest. Okay, take a look at what are the factors that seem to differ from common law and civil law. Issues like litigation costs, issues like delay and speed, issues like like disclosure of information. And I think you're right. It's much better to look at those individual characteristics than to try to make rather overall classifications. The one disadvantage, of course, of looking at individual characteristics is it's really hard to gather all the information about the individual characteristics. So, for example, we did a lot of work trying to figure out the information about disclosure of information and when is information disclosed. It's just really hard. I mean, I've read a lot at this point of, civil procedure manuals from Australia and Sweden, and, it's really hard to figure it out. And in part because the systems are so different, the role of disclosure is different in a common law country where a trial would be 2 years after filing versus a civil law system where, at least on the German model, you'd be having a hearing and hearing witnesses in stages. But your overall point, I think, is very well taken. Legal origin is a very crude way of analyzing things. And if we really want to understand things, we need to dig deeper, analyze the individual procedural choices that make the different systems different.
Okay, that's great. Now another question from the audience. Please, Isabella Garbellini, my former student, great having you here. It's your turn now. Go ahead, please, Isabella. Isabella, are you there?
I think she's muted.
Okay.
Are you here? Okay.
Yes.
Thanks, Dan. You are the man.
It's a pleasure to learn from your research. I'm asking a question made by Isabella Rangel, okay? She's asking if you could explain more about what are simple mutual optimism models, and if this concept is connected in any way to the practice of mediation.
Excellent. Okay, so going back to the early 1980s, actually back to the 1970s, in the beginnings of the law and economics movement, mostly in the United States, one of the things that the early pioneers in law and economics, including Judge Posner and Bill Landis and other people who've less famous tried to do, is they tried to understand the process of settlement. And in the first generation of scholarship on that, the pioneering work in the 1970s, they developed a set of models which we now call mutual optimism models, where parties settle or don't settle because they have different estimates of the success of the litigation. And so you wouldn't have a settlement if the plaintiff was very optimistic about winning, and if the defendant was very optimistic that the defendant was going to win. When both parties are really optimistic about that they're going to win, they don't want to settle, or they won't offer very much in settlement. And so those early models are called mutual optimism models. And they do have a significant connection to mediation, because one of the things that a mediator can do is help give people more realistic ideas about what their outcome of the litigation is. So if being too optimistic about winning is part of what causes people not to settle, well, a mediator can tell the parties, look, I don't think you're likely to win. You, the plaintiff, your case isn't as strong as you think it is. And hey, you, the defendant, you've got more risk here than you may realize. Now, as you probably know, there are different philosophies of mediation. And what I've described is sometimes called evaluative mediation. And I think evaluative mediation can really help when it comes to that mutual optimism. On the other hand, some mediators think that it's improper for the mediator to express any views on where the merits are or how strong the case is, and they're solely trying to get the parties to talk to each other and overcome psychological barriers. So I think that the mutual optimism models are closely related to the evaluative models of mediation.
Thank you.
You're very welcome.
Professor Luis Reichert, please, your turn now.
Professor Klerman, I have a question from Enzo Banvart Leite Stefani. He asks, can also the social insecurity, he means the culture of not trusting one another, contribute to this low settlement rate scenario?
I'm sorry, not trusting one another, is that what you said?
Yeah.
I hadn't really thought about that. I'm not sure how much trust plays a role here, in the sense that a settlement is a binding contract, and it usually you don't, and even if it's not a binding contract, usually you require people to pay pretty quickly. I mean, settlements can involve a structure of payments over time, but most settlements, at least in the United States, involve a single, pretty much immediate payment. So I don't think trust is all that important. On the other hand, you need to have enough trust in order just to negotiate. You need to be able to have that lines of communication, and you need to. But trust overall, I hadn't thought about it, and I wouldn't think it would be essential to the settlement process.
You talked about disclosure as a factor in this scenario. I'd like to hear from you about the moment in the procedure. In Brazil, we had an experience that the settlement agreements would be built before, a long time ago, in procedures only after the defendant has shown his arguments and so on. Now, in civil procedure, the rule is we have a settlement meeting before this moment of the defendant to show his arguments. I don't know if you have taken it into account in your research.
You know, I think that would be a great thing to study. It would be wonderful to see what elements happen before or after the disclosure of information. We don't have any data which allows us to study that particular question, but you know, people who have more fine-grained data from various countries, it would be great to see that information. In part, that's the pre-filing versus post-filing question. So when you have a settlement which occurs before the case is brought to court, well, then it's before any mandatory disclosure. In the United States, the mandatory disclosures, there are many complications to it, but in general, the disclosures are relatively early. And so most of the settlements would be after at least the first round of disclosures. But in the United States, there's multiple rounds of disclosure, so it's not clear exactly which one you'd want to count. But in the United States, for example, you are required before trial to make known to the other party basically every piece of evidence, every witness, every document that you are going to use at trial. But I think that'd be great to figure out whether people generally settle before or after those disclosures, and I don't know. It's a good question.
Galari.
Okay. One more question then?
Sure.
Okay. If we were in Brazil, after this question, we would go to a bar. I don't know if like beer or wine or whatever. I would drink orange juice, but we would go for hours. But it's Zoom, so we have to, unfortunately, have to end this.
It would be a lot of orange juice.
Yeah, yeah. So for our last question, Professor Rodovalho, once again, please.
Well, we have one last question from Frederico Kohler, also a judge here in Brazil and a professor. He's saying, good evening to everybody. Thank you. Thanks for the wonderful lecture. Professor, is it possible that high litigation costs, not only punitive damage, but all the costs with lawyers, fees, and so on, could stimulate higher settlement rates? When costs are too cheap, maybe it's better for both litigants to wait for the final decision. What do you think about that? And thank you for your time.
Sure. So I completely agree with that suggestion. And when we talk about litigation costs in the paper and in the slides that I presented, those litigation costs are the lawyer's costs. We're basing it on surveys that were done by other researchers of primarily lawyers' costs. There's also a little bit of filing fees and things like that. But when I refer to high litigation costs, I'm referring not to the damages that the court awards, but to the lawyer's fees and the filing fees. And in most countries, the lawyer's fees are the primary part of that. And so I think that's absolutely right. High lawyer's fees and lawyer costs are a primary incentive to settlement, because as much as lawyers might drag things on, their clients, who usually have control, don't like paying their lawyers.
Okay.
Thank you very much.
So it's more than 2 hours then from the beginning of our chat. for our great time together. Thank you very much, Dan. It was really good. Besides from the chat, we have lots of groups now, people saying, oh, what do we have to do? Whoa, that was a great answer. So thank you very much. It was way beyond of what we thought would be. It's 2 hours and we still have more than 60 people here. So that's awesome. Thank you very much. I appreciate for your time, for your patience. But once again, you have to come to Brazil. Come on. Don't go to Africa or Europe. Post-COVID-19, Brazil is the place to go. The top of your bucket list, please.
Absolutely.
When all this is over, it would be great to receive you and Yun-Chien here. Thank you very much. Final remarks.
Very much appreciate it.
Any final remarks, or we are done? Or are you done?
My only final remark is just to say thank you very much for paying attention, for being interested, for your excellent questions, and for your hospitality. Even over Zoom, I can tell how hospitable you all are. So thank you so very much.
Okay, thank you to everybody. It was awesome. It was great. We have the record of this event. If you want something later, just ask one of the hosts. And if you do not have yet the paper, also ask one of the hosts. We will send you because, of course, Dan and Yun-Chien kindly said we could share with everybody.
Thank you. And we have a more recent version than the paper that you sent, so we'll send a more recent version to you. We're still revising it, but we'll send it in a day or two.
Okay, awesome.
Thank you so much.
Bye-bye, Dan. Thank you.
Thank you. Thank you very much.
Thank you.